Hello, everyone. Welcome to today's seminar. My name is Hui Jing, the Deputy Director for Chinese Law Center. So today we are very honored to have Professor Yang and Professor Long Xuan as our speakers today. Professor Yang is an assistant professor at the City University of Hong Kong. He's working on intellectual property law, especially on the topic of trade secret. And Professor Long Xuan is an assistant professor from Tongji University. Sorry. Yes, and he's a sociologist. So both of them are the rising stars in their respective fields. So today's seminar consists of two sessions. The first one is a presentation lasting for 30 to 40 minutes. The second one is a Q&A. So without further ado, I'm now handing the stage over to Professor Yang and Professor Long Xuan.
Thank you, Jinghui, for the introduction and for inviting us here to do the seminar, which is one of our recent research paper. As you can see in the title, it's an empirical study on non-compete agreements. It's actually not a very new study for us because we conducted the research data collection back to 2024, but still the findings and the discussions we will talk about are quite related to the recent statutory and also judicial movements in mainland China concerning how to regulate non-competes. So let me first introduce very basics on the non-compete agreements first, in case you are not familiar with the field. When we talk about non-compete agreements in the employment context, signed with employees, we are basically referring to those agreements where the employees, they agree to not join or any competitors or start up any their own competing businesses after they leave the original company. So that's the non-compete agreements. The function is to trying to prohibit the job hopping of departing employees. And if you know something about non-compete agreements and employment law, it's actually mainly functioning to protect trade secrets or other information assets of the employer, because the employers are trying to prevent employee from joining any competitors where if they join, they will just share the information they know from the employers. That's why the main function in most jurisdictions law in terms of non-competes, they are mainly trying to protect trade secrets or other confidential information. And we always consider the non-competes as a shortcut for trade secrets protection, because when employers, they have valid non-compete agreements and then sue under non-competes, they can just very easily say there is a non-compete agreement signed, which is valid. And then if the departing employee join any competitor, they need to be held in breach of the agreement. And then there will be liquidated damage awards being awarded. Instead of having to go through the full-length trade secrets litigation, which is mainly very similar to other IP families, that you need to prove the information is actually a protectable trade secret. So, but by saying that, you can see non-competes, they are inherently controversial because we are preventing the individual's rights to earn a living and to work in another company, and which is a fundamental right in many jurisdictions. That's why ever since the inception of non-competes, different jurisdictions, they are trying to adopt very various rules in terms of regulate to control the potential abuses by the employers. Therefore, if you look at different jurisdictions, their approaches may be different, but their aims are very similar. They allow general enforceability of non-competes, but they will set a lot of different standards for the non-competes to be reasonably compatible with the interest to be protected by the employer. So the main jurisdiction we are focusing on today is China. I want to give you a very brief introduction to what we call law on books in China in terms of how they regulate non-compete agreements. Actually, if we think of the Chinese law on non-competes, the main legal source should be employment contract law, which is a statute, as well as the related judicial interpretations. But just on the face of it, Chinese law provides quite detailed and relatively clear standards on enforceable non-competes. only 3 categories of the employees can sign non-competes upon receiving a request from the employers. And if you look at those 3 categories, they are senior employees, management or senior technical staff, or other employees with confidentiality duty. So all the 3 categories, they are the ones that are more likely to get access to trade secrets or confidential information when they work in the prior employer. That's why the main function of non-compete in China is also about protecting trade secrets, which is the benchmark. And because if any employee is under the duty of non-compete, they have to wait a certain period before they can join the competitor. So the law also stipulates that during that waiting period, there should be economic compensation, financial compensation from the prior employer, which normally will be more than 30% of the average wage in the last annual average wage. And the duration should be no more than 2 years. So which is a very, very clear and short period. If any duration beyond 2 years will be inherently considered as invalid. And also in 2025, the Supreme People's Court promulgated a new judicial interpretation on labor disputes, which partially touch upon the further regulations on non-competes because, as you soon will know from our slides, in 2024, there were a lot of scandals or complaints from the then departing employees concerning the abuses of non-competes by employers. That's why the Supreme People's Court promulgated the 2025 version for the judicial interpretation. Within it reiterates the requirement that non-competes, the scope should be reasonably compatible with the trade secrets that the departing employee they ever get access to. And they also emphasize that if the departing employee under the non-compete agreements, they do not have access to trade secrets, they can try to challenge in court to invalidate the non-compete agreements. So if you look at the law on the books, on the face of it, sounds to be not that uncertain and quite good balancing concerning the rules, trying to balance between the legitimate interests of the employers and the right to earn a living by the employees. But back to 2024, there were a lot of complaints by those employees under non-compete duties in social media. And they try to describe that they were victims of the abuses of non-competes by companies. So you can see that 2024, a lot of them, we only listed some examples here, with a lot of them, they were only like fresh graduates or only work for this company for like months. But then they were also under a very harsh non-compete duty agreement, with a very high liquidated damage clause written into the agreement. And also, even after the promulgation of the 2025 judicial interpretation, many on the social media, many users they still kind of questioned the validity of the judicial interpretation in terms of regulating the non-competes, and they complained that in practice, probably the effect should be very limited. They are still under non-competes, and the companies are still abusing it, and they still cannot find a way to get rid of it, even though we have a judicial interpretation trying to reiterating the requirements for trade secrets. That's why we want to do this study in terms of trying to empirically explore the practical situations of non-compete agreements experienced by those employees who are under non-compete agreements. The reason is that if we look at the current literature, either it is empirically overlooked, no empirical study, very limited, or the very, very few, 1 or 2 empirical studies touching on the point, they are most likely to use the judicial decisions, court decisions. But if you know something about labor disputes in mainland China, most of them, they do not go to court proceedings. They either go to the employment arbitration process, which the documents you can never see because they're confidential, or they will just go through the private settlements, which is even more common as compared to those judicial proceedings. That's why the current studies could not provide us any insights in terms of the gap between the law books and law in practice. So we want to do this empirical study to explore the perceptions, interaction, experiences concerning non-competes. Now I will hand over to Professor Zhao for our research design and empirical findings. And then I will finally conclude the legal discussion points.
Okay, so thank you for Professor Chen's introduction. And as Professor Chen introduced it, that the previous studies like the doctrinal study or some very few empirical study cannot uncover the all context of the non-competes which influence the normal or ordinary employees. So what we want to pay specific attention to is the normal employers, not normal employees. So we choose the theoretical framework called the legal consciousness. And actually, legal consciousness emphasizes that the law is not only can be interpreted on the book or by the books, but also by the normal people. Like the people will have their own understandings or their perceptions on what is law or whether the law is good or not, or what the law is for, like protecting which people or something like that. So we use the legal consciousness as our framework to care more about what the normal people think about the law, especially like the non-competes. So we use the legal consciousness, and as the advocate, CB defined that legal conscience actually is individuals' agentic perceptions, evaluations, and beliefs about how legality is constructed, formed through their lived experience. So we want to highlight the lived experience, their own everyday life encounters or experience within the constraint of the social structures. And they identified three dominant orientations of the legal consciousness. The first is before the law, so which is people believe the law, or people like the law, people believe the law is legitimate or good enough, so they can believe that law is neutral rules or objective rules. And with the law orientation means that people can learn the law and use the law to gain some profit or their own benefits. And against the law means people find that maybe the law is unfair, and they try to use some tactics to avoid the influence of the law, and like to use the everyday tactics of the evasion, subtle obsession, and creative reinterpretation of the law. So these three is very important to understand the legal consciousness. It's a kind of framework. So that means the legal consciousness is not very stable. It's very changeable. So it's a kind of dynamic and reflective construction of individuals' unique interpretation of various aspects of law, because sometimes maybe the normal people encounter a very specific case and they will change their mind on the what is law. So that means the legal consciousness is very various or dynamic. And we not only use these three as our framework, actually we also involve some other concept about the legal consciousness. The first is legal alienation. So that means people do not want to use the law. People want to be away from the law. So that means probably low expectations, low participation, and low identification with the law. And the second is under the law. So actually under the law is a kind of supplement to the three orientations framework. So under the law means people feel like totally disagree with the law and try to advocate a kind of reform of the law, the reform of the all of the legal framework. So that under the law is more like the more extreme, maybe on the if there is a spectrum, under the law is maybe a kind of how to say heavier than against the law orientation. So, and the second order legal consciousness, like maybe you can imagine that people do not only generate some understanding about the law based on their own experience, but can also based on others' experience. So that is second order legal consciousness. So we also contain these three concepts in our framework. And for the research method, because it is empirical study, and we choose the qualitative approach. First, we recruit 20 informants from the social media, from the Weibo and the Redbook. And here is a kind of very basic information demographic information table. And you may see that we also involve some people have the legal background. Because in previous studies, actually in the empirical study, which focus on the legal consciousness, they specifically involve some people have legal professionals or legal background. And we also found that people have the legal background have some kind of different attitudes or the different legal consciousness, and we will introduce later in our findings. And because you know that in 2025 there is a new judicial interpretation issued, so we also collect some posts on the Red Book to supplement our interview data. We collect 344 screenshots from 124 random posts as a kind of data collection. And for the data analysis, we use a Sedanius way to do the two-cycle coding. So that is kind of semantic analysis way to do the data processing. Okay, so for our findings, the first thing we want to, actually we identify 3 moments. And the first moment is to sign the non-competes. And at this moment, what we want to introduce first is the theme called the structured asymmetry. Actually, that means employees typically sign non-competes with very constrained agency for refusal, because like the I4 said, actually the non-competes can be one document within the, she used a very interesting metaphor, the welcome package. And if you want to refuse it, what is waiting for you is the departure package. So that means actually refusal may equal loss of job opportunity. And also other informants emphasize this I3 and I5. Emphasize the HR staff will say that everyone has to sign it, or if you do not sign, you cannot join. So that is kind of, yes, people can say no to the non-competes, but actually in that context, they may do not have the power, or they may do not have the choice to say no. And here, so why people will, or what people then will do is show a kind of legal consciousness of legal alienation, actually, because they feel like it is powerless of the legal framework. But we identify 2 different forms of legal alienation. The first we found is voluntary, because people will think about not the legal framework, but also some actual legal elements, like their future or their career development. So like I said, because it is a pandemic, after pandemic lockdown, they find that it's very hard to find a job. So they very value a kind of opportunity to have a kind of job. So, and his own future plan is also not to continue in this industry. So he do not say no. It's not because he do not want to, because he feel like he don't need to say no to sign the non-competes. And also, I certainly said it's very remote. The result is very remote. And I remember a post where an interviewee said that you will not imagine your resignation or offboarding in your very first day of you joining the new company. So they voluntarily see that choose to do not use the law. And the second form is involuntary. So that is what maybe most of people will meet. So employees may not be unwilling to consider and exercise the rights they may have under the current legal system. Rather, employers provide no opportunity for them to do so. So that is because maybe the signing process is very accelerating, and there is no any advance notice or advance information that tells those employees that there is a kind of documents called non-competes. In those documents they need to sign. So there is no advance notice and very little explanation. If some employees ask what is non-competes, the HR just said everyone has to sign it. Okay, so maybe people sign it. And also to lower the visibility of the non-competes. Some posts say that even after signing the non-competes, the companies, the employers do not provide any copies of the non-competes to them. And one post said they even sign a kind of blank agreement, but just sign on the agreement. So that is very tricky. Yes. So here are two kind of different forms of the legal alienation, but people choose not to pursue the legal help or the law help. Okay. But also there are some people express a kind of before the law orientation, like the legal consciousness, like especially those people who have the legal professionals. They acknowledge that they acknowledge that the non-compete's core function and underlying rationale of it, because they believe that like the I3 said, the non-compete is not only protect the employers, but also it protect the employees, because it will provide some kinds of very how to say the compensation, but it's 30%. Maybe the law just rules that it should be more than 30%, but in fact, most of the non-compete agreement just be the 30% of the average wage of the last year. So, but some people will believe that this law govern the non-compete very rationale, because it has their own, it has its own it has own meaning behind the rule, and but also after acknowledging the rationale of the non-compete, I3 also emphasize actually it is overcorrection now. So because the company require nearly all employees to sign non-competes. So this is what we find also in our next part. When the next second moment we identify is when people thinking about the job hoop, like many informants actually highlights that they cannot realize the existence of non-competes in their daily work because the lower visibility of the non-competes. But when they think about whether they need to change a job, they will revisit the documents they signed and they found the non-competes. So that is the second moment, which is very important when people interact with non-compete agreement. So in this moment, we found that under the law, conscience emerges very commonly. Like how to say, yes, here, although the many informants believe or acknowledge that actually in their non-competes, there are some very specific requirements, like the law says they need to involve in, but like the financial compensation or the cap for duration of non-competes 2 years, less than 2 years. But the non-competes be very silent on many other important elements, like the amount of competing companies and the range of employees who restriction is justified. So here are two very key complaints about the non-competes. The first is overly broad competitor lists. Because the law didn't say anything about the range of the competitors can be involved in the non-competes. So the employers basically list all the companies in the industry on the non-competes. And I also said beyond naming, but just to give a very how to say rough range of the companies. And another post also mentions that it's not only within the China, but also in the whole world. So that is all the industry, all the companies can be listed on the non-competes. So many of our informants and posts complain this. It is very overly broad competitors list and a very sweeping range of the competitors can be included in the non-competes. And the second is also very sweeping range of the people who sign the non-competes. Even I4 just described himself a very recent graduate in a very junior level position. And I10 refers that employees in the outsourcing firms. And one post said even the janitorial and security staff can be regarded as people who should shoulder the confidentiality responsibility to sign the non-competes. So it's also a very sweeping range of people who sign the non-competes. Like, yes, or categories by the employers as subject to confidentiality obligation, because the law just says three kinds of people should sign the non-compete. The first two is senior employees, but the third one is very, how to say, very in a very weak sentence, like the people should shoulder the confidentiality duty. So they will utilize this kind of rule to elect nearly all the people to sign the non-competes. So these two key complaints, like to how to say these two key complaints to make the people have the under the law legal consciousness, because they feel like it should be reform the whole legal framework as the which governs the non-competes, and even the judicial interpretation too says something about the who should be considered as the people shouldering the who should be regarded as the people who have the responsibility of the confidentiality. But actually, our data also says that actually who can define the people have the genuine access to the trade secrets is still controlled by the employers. Like they said actually the authority of define what counts as secret trade secret still belongs to the company, and they can just send an email to everyone's email, then say or everyone should have the access to the trade secrets. So that is our post set. So we will see that although there is a kind of judicial interpretation too, but actually maybe make very little impact on the employer's power or agency on designing the non-competes. So here, what we want to highlight is our informants, our data actually express a kind of distrust of legal remedies. Maybe people will say, okay, so why do not those people try to fight some legal remedies or try to make it as a kind of lawsuit? But actually, for our interviewees, they said it actually is very costly, slow, and risky. Like the I-8 said, many people have to invest substantial time, effort, and money upfront, retain counsel for advice, and only then can they seek to vindicate their rights. In the end of the drugs, on for a long time, during which they cannot work, and the costs are very heavy. So he emphasized that even if the outcome is favorable, it would still feel like a loss. So actually, there are seldom people try to make it as a kind of lawsuit or try to pursue the legal action. But here is also a kind of exception. Like those people who have the legal professionals, they still believe that they can use the law and try to fight for the kind of unfair agreements. So that is not all the people have the distrust of the legal remedies, but instead of the people who have the legal professionals. So we need to highlight here is a kind of exception. And the third moment we identified is the law in action, actually. So after the offboarding from one company, some people will see that their non-compete agreement didn't activate because maybe the employers feel like there are high compensation obligation or the limited role sensitivity, and they believe that maybe the employee go to a new company has a kind of collaborated relationship with the original employers, so they will not activate their non-competes. But most of our data sets, their non-competes have been activated. So that means there is a real impact on their career development. And in this process or in this moment, they actually generate a very complicated or a very mixed configuration of legal consciousness. So actually, they first emphasize a kind of unequal distribution. They can realize that non-competes has been used to substitute for trade secret litigation. Like in in the documents they cite in their first day, it's not only the non-compete, but also maybe the confidentiality agreement. But people realize that actually the non-compete has been used as a kind of substitute to the confidentiality agreement because the non-compete is easier to enforce and the lower evidentiary burden. Because confidentiality agreements are hard to investigate, said by the I-19, and it's much harder to prove a violation of trade secret law than to prove a breach of a non-compete, because only employers just need to find that you went to a company on the competitor list, then they can see that you violate the non-compete. But it's very hard to prove that you tell the trade secret to someone else. So they use the non-compete. So our data says the non-compete has been used to substitute for the trade secret litigation. So even they believe that these two agreements are lawful or should be signed. Yeah, because they acknowledge that the law also need to protect the employers' benefits, like to their own trade secrets, but they will change or they will transform their legal consciousness from the before the law to the under the law when they realize that actually the non-compete has been used as a kind of substitute for the confidentiality agreement. So I3 said, if I disclose any information, the company could pursue me under the confidentiality agreement because they also signed that, or they also signed it. There is no need to restrict the industry they can enter. And P54 still said it's a very severe exploration of labor, a blatant exploration. So that is why they feel like, although these two agreements is very appropriate, they need to sign, but then they find it's not fair. It should be not used in this way. And the second, they emphasize a very great amount of liquidated damages. And actually, the existing legal framework for non-competes provides no any guidance on the standard for the reasonable liquidated damages, leaving substantial discretion to employers. Actually, there is one industrial policy says something about the standard of the liquidated damages, but the industrial policies has no any legal power. So employers do not need to listen, do not need to listen to the industrial policies. So then what the employees will face is a very big deal of the liquidated damages. Even just they have only 30% of the compensation of their own average wage in the last year. Like the posting P95 said, the liquidated damages amounted to 198 times the compensation, reaching 4 million yuan. It's not the only case, but there are so many cases we found on the social media, on the post. Even in the 3 cases the Professor Chen just mentioned in the previous slide. So, and P27 even said they find that it's a tool for the companies to extract money. Yeah, because even you are in a very junior level, you can be sued for a very big deal of the liquidated damages. So they said it's a kind of manipulation of liquidated damages by the companies, by the employers. So it's still a kind of under the lower legal conscience because people feel like the law should be reformed to raise the cost for enterprises to use non-competes and to promote standardization of compensation. Yes. And third, what they emphasize is the unpredictability of non-competes. Actually, although the law says the non-competes should be activated within the 3 months, so that means the employers should send the compensation to the employees within the 3 months if they want to activate the non-competes. But actually, in fact, people do not know when the non-competes will be activated. In our data, even some people leave the company for more than half a year then the company sends the compensation and say that the non-compete has been activated. But maybe some people is not very familiar with the law knowledge, because that is a kind of threshold of the legal knowledge. So maybe not anyone know those kind of very specific rules. So they feel like their non-compete has been activated. So the employees, what they will face is very uncertain and hesitant context, the situation, whether they need to accept the new employment, because they don't know when the non-compete will be activated. Like P93 said, nearly 3 months after leaving, they suddenly received last month's non-compete compensation from their former employer. So then that means the non-compete has been activated. But actually, even some, I remember even some the informants said in their last day in their previous companies, the leader, the HR staff said orally that their non-competes will not be activated, but maybe 1 month later or 2 months later, their non-competes has been activated. And I remember one post said even there is a paperwork that their non-competes will not be activated, but then their non-compete has been activated. So it's very unpredictable, and the whole power controlled by the employers. So that means, as a result, even after offboarding, the mere prospects of activation function as a symbolic deterrent that employees continue to live with.
I will continue with the final points on the empirical finding, because it's related to the legal discussion point of the my first point to talk about. So instead of giving you the empirical findings in this way, I want to highlight the firstly the legal discussion point I want to talk about first, drawing from our legal discussion. So now you know a lot of different kind of the findings surrounding the non-competes, but then let's go back to the theoretical foundation or focus of non-competes. They are aimed to trying to protect employers' legitimate benefits in terms of their trade secrets. And normally, imagine a company, it will normally be those senior employees and those ones who are high talents. They have more frequent access to top secrets. Then the non-competes from a theoretical way should be more likely to be used to restrict those high talents or high level employees from job hopping. That's the theoretical aim of the non-competes under the theoretical foundation of a few points. But if we go back to the final empirical finding I want to highlight, the situation in practice will be very, very different, because when we ask or interview those senior employees, those ones who work in the industry for like more than 5 years or who are very high talents, they are truly have those genuine access to top secrets. They always mention the points with us like, well, we don't care about non-competes that much even we sign it. Why? Because either the next employer will basically pay the liquidated damage for me, and they will find different ways for me to evade the detection of non-compete duty, even though they will join the new employers. Because those new employers, they want those talents, they want those senior employees, and they will try their all means to help them to avoid the liability, or even if they are detected, they will pay the damage awards for them. And also, some of those senior employees, they mentioned that, well, I don't care about non-competes because even though today I'm limited to join the whole industry companies, I still learn a lot of cross-industry skills. I can choose another one in another industry. That will not harm my benefits that much, because I'm already in the position for years. I've learned a lot of different skills. I can apply them to other industry members rather than this whole industry. And also, some of them, they also mentioned that, well, it's actually good for them to have a break because they work for so many years. They have earned some money, and then they will just take a gap and then to see what other opportunities in the future. And they will not consider like the gap here will be so devastating for them, for their career, because they have already been in the industry for so many years. But all of those things that those senior employees, they mentioned the legal consciousness that they can use the law, they can evade the law against the law, does not exist in any circumstances for those junior employees. Because for many people in the field, they are only have less than 3 years experiences. And then they mentioned that, well, I don't have any companies to be backup for me because I'm too junior. They will not pay for me. They will not find ways to evade the non-competes. And also, I'm really afraid of some of them. They say they're afraid of non-competes because I don't know what will be my future. And they are the ones that if they take the gap year, their career path will be influenced a lot. Because many HRs in mainland China, for those juniors, they will say like, why you take a gap year? Why you don't go to their company? How do you remedy the full year or for 2 years that you get out of the industry, don't get updated information? So that will be a very significant impact on those junior employees, and they don't have those backup. And also, they are under a little bit severe surveillance or intimidation by those prior employers, because we also learn that some of those employers, they will hire private investigators to just trying to see whether that employee joined any competitor or not. They will take photos and check their packages, the address, and also trying to take a photo of the cars they park on the parking lots and to see whether that parking lots belong or related to any competitor or not, and to censor them, and to even let them give them updates on their insurance screenshot every month to let the original company know they are not joining any competitor. Because if you have any knowledge of mainland China, if you're going to a company, you will automatically, the employer will pay for the insurances for you. And then there will be an account indicating how much insurance in each month that the company pay for you. And those departing those employers, they will require those employees to send them the screenshots every month to let the employers know that they don't join any competitors, because this is the official record. That's why the first legal discussion point I want to highlight here is that there is a deviated, misplaced practical focus. We aim to protect trade secrets. We aim to prevent those high talents, senior staff from job hopping so that they will disclose and use the trade secrets in a new company. But in the end, the non-competes cannot truly function to deter the job hopping by those senior employees. The most significant influence group will still be those junior employees. They are not the theoretical focus of non-competes because they normally don't have access to a lot of top secrets. And they are the ones truly need to go to another company to earn their experiences. So that's a very huge misplaced practical focus. And finally, the final point I want to mention from all the findings is that what I call enhanced factual secrecy, but unrestrained trade secrets expansion. Because the original function of non-compete should be to just supplement trade secrets protection rather than replace it. But now the non-competes basically ranging to all competitors, to all range of employees. And then those employers, they don't need to prove there is an existence of any valid trade secret any longer. It means that any limiting doctrines within the trade secrets law will basically be evaded by using non-competes to serve as the substitute. They don't need to prove. And the defendants, they will have no chance to argue that they are not infringing trade secrets. They cannot use those defenses designed within the trade secrets law. So the trade secrets protection will basically be expanded in an unacceptable way. And then the trade secrets law will basically lose its function to maintain the balance. And even the judicial interpretation too, trying to re-emphasize the link between non-competes and trade secrets. But remember, confidentiality agreements can list every piece of information as trade secrets, and then making every possible employee as persons under duty of confidentiality. And then they will still need to sign. Even though we can say like, well, the judicial interpretation gives you opportunity to challenge in court. But remember the findings Professor Zhao just mentioned. Many of those employees, they don't want to, and they don't have the resources to do. And they don't want to also build a reputation that they are the tough guy, because the industry is not that large as we can imagine. The news can transcend to other companies. So they will not use the legal methods. And needless to say, it's very lengthy and costly. So it means that it's still meaningless in terms of that, like many of them don't use it. The trade secrets law cannot, or trade secrets claims cannot be proven in non-competes, and it's still non-compete litigation rather than trade secrets litigation. But even though we jump a little bit from that and to say like, well, still there are some employees, they will use the judicial interpretation to sue the prior employers, then there is still a layer of judicial uncertainty. Now let's imagine if the courts they require proof of valid trade secrets in non-compete disputes. It means that the non-compete disputes will basically be similar to trade secrets litigation if you need to prove all the elements as the Supreme People's Court mentioned. Then why we provide both channels? If then both claims they require similar burden of proof, then why we allow non-competes while also allow trade secrets protection if they need to prove the things they need to prove will be the same in the end. So there are a lot of different further questions that we cannot prove or we cannot deal with, which is the normative one. How should the non-competes, what will be the future for the non-competes? Because now in empirical findings or discussions just to spot the issues, there is no space for us to solve the issue. But frankly speaking, up to today, I cannot figure out any feasible way to deal with the issue from a legal perspective. But one potential solution I may have in mind is probably just ban the whole non-compete. Let's move all the litigation to the trade secrets protection. But that one is radical and it's not supported by the empirical findings so far. But that will be the further questions leaving to the audience and leaving to future scholars to build on. What will be the future for non-competes? How can we truly figure out a alternative way to better regulate the non-compete agreements? So we will stop here and then we will have some minutes for Q&A. And thank you for listening to our presentation. Oh, one more thing. Our paper is not finally out. It's not finally published, but the preprint version is already uploaded online on SSRN. So if you are interested in more details of our findings, our contribution, you can download it online and then welcome any comments and suggestions.
Okay, thanks so much, Longxuan and Yang, for your wonderful and insightful presentation. We now have 10 minutes for Q&A. So now let's open the door for Q&A. If you have any questions, comments, or suggestions, please feel free to raise your hands. But when asking the question or giving comments, we are very grateful if you can introduce yourself. Yes. Okay. Yeah, Fangxin.
Hi, my name is Xin. I'm a lecturer at Hong Kong U Law faculty. It's a very interesting study, especially when you describe the stratified responses to non-compete. So basically what I felt was this is basically a study of the abuse of non-compete provisions in the industries. So during your research, did you see any so is this abuse a general practice among all industries, or are there worse offenders? So that's one question. The other one is, do you see different patterns within, for example, state-owned enterprises, private domestic enterprises, and foreign invested enterprises in China?
A very good question for the industries. So when we designed the study back to 2024, we actually thought of whether we need to divide between industries and to see whether there are any different patterns across those industries. But in the end, we did not choose to do so. We want to frame this research to be more general because we don't want to presume any differences at the very beginning. So that's why when we recruit those informants, we did not ask, limit any industries. We just let the data to go. Like anyone interested, we will interview them and to see whether they have anything new that we can dig out during our interviews. So in the end, because you see, if you back to our demographic information in the very beginning, there are actually many industries we interviewed for those employees, but the patterns of the consciences they show to us are very similar. The only difference will be the legal one. The legal profession, they will normally have more like they have the confidence in the legal system, and then they say like they can use the legal methods to remedy their harms, etc. But for many others, they are very similar. That's why in the end we still did not divide industries, because now our data is basically reinforcing with each other, and we don't see the needs to do so at this point. But that one is also actually one of my future direction I want to see. If I just focus on one industry, whether the results may be different. One industry I consider or have anecdotal evidence considering may be different will be the financial industry, because in many Chinese companies, which if they work in the financial one, they normally don't use non-compete agreements. They are more likely to use the garden leave clauses. When we talk about garden leave, it means that they will still let the employee not working for a period, but still they are under the employment contract. But it's basically like 1 year before the actual resignation day of that employee will basically give him the wage in full, and then the employee can go and can just stay at home, and they will not have access to the systems in the company, so that we can call it the garden leave. Like they can go back home, don't need to do the work, receive the wage, but still because 1 year, if 1 or 2 years passed, then they will not have the updated trade secrets any longer, and then they can just leave the company to join a competitor. So the garden leave clause is more frequently used in the financial industry, which I suppose will be having different kind of consciousness if I interview those financial employees. But that's just from the anecdotal evidence. And I don't have more data on this point so far, but should it be a very interesting one to explore in the future. So that will be the industry. For whether it is still state-owned or private-owned, etc. Again, we haven't divided it yet, but we assume, or based on my memory on the informants, most of them are private-owned companies. Our data, because which I suppose you can understand for those state-owned companies, employees, many of them, they will be more reluctant to talk. And it will be very hard to dig any deeper information from them. And the tricky thing is that during our interview, we also don't want to let the other side to sense that we want to know their information. So we will not ask the name of their company. We will only ask their industry and the work experience. So we are not sure whether they are actually private owned or state owned, because we cannot ask. If so many informants, they will freak out and say like, well, if I give you too much information, then you may locate me. And then I will feel risky, because now that part is a little bit sensitive in the end. So that will be one point. But yeah, I hope it answers your question.
So much. Yes.
Thank you for your insightful sharing. And I'm studying in PKU in Shenzhen, and I got a bachelor degree in medical. So some patients will use media to solve their problems, even if it cannot be scientific solved through law. I was wondering, is it a smart choice to use public opinion or public media to raise some comments or consensus to solve a personal issue? Will that be a smart choice, or I want to know something about it.
Well, it's very hard to see. Actually, I'm an assistant professor in the media, in the communication studies. Yeah, but my PhD is in sociology. So in media, in communication study, we always talk about this topic, that whether a personal issue can be amplified as a kind of public issue. And sometimes we will feel like maybe that is the last choice an individual has. Like if they can pursue the legal remedies or other help, like the institutional help. Like you may notice that there is a news from Sichuan University, these days recently, and we it's very hard to say that whether they should or it is right or wrong, because how to say, like in the media industry or in the communication studies, actually everyone has the rights to post anything. Like they can post their encounters or their bad experience on any aspects. And in a very common way to see that we will see it's useful, but whether it's right or wrong, I don't. I have no further comments about it. Yes, I don't know whether can be interpreted in a legal.
I don't know, but just from the non-compete scenario, I will see it a very useful way in general, but not for that person individually. Because remember the 2025 judicial interpretation 2, the reason for promulgating it was because of those online posts. I still remember in the summer of 2024, in Weibo, there was a Weibo post from which I think it should be the first example in the slide. The recent graduate only worked for 4 months. I suppose it's Pinduoduo or Jingdong, can't remember which one, but anyways, it's like only worked for 4 months, but the amount being claimed by the company was very, very high. And that person felt basically desperate because he was from a not very rich family. So he, while going through the legal proceeding with the employer, because that person was being sued, he also posted the whole full-length Weibo post on Weibo and trying to solicit any help from those other social media users, and also trying to use the social media as a way to let those policymakers know what is truly going on in the society and in the reality. And I suppose it did help because many others, they echo that post. And then there were more complaints and scandals posted on social media, not just Weibo or as well as RedNote. And then I think it's just 3 or 4 months later of that post, the Supreme People's Court released a press, I think, article or WeChat article, and trying to say like they are holding some meetings to discuss the current abuses of non-competes by some industries, and then they will figure out the way to deal with that. And then in like 9 months later, in September, or I think, or half year after the June or July of the September, they promulgated the 2020 version of the judicial interpretation. So I have to say, it do help in certain way, but do you think it's truly helpful for the original one posting his desperate stories? Probably no, because his litigation was still ongoing, and then he was has already received the judgment just very few months after his post. And then what has been done is been done. It's just like maybe beneficial for future employees, but not necessarily for the original one. So my answer will be, well, I'm not sure, but at least in a general way, it does help in a certain way.
Okay, thanks so much, Yang. Now is 12 and mindful of the time because as a moderator, I need to perform my duty diligently to ensure that we do not overrun. So please join me in thanking Professor Yang and Longxuan for their wonderful presentation. Yes.